Thank you very much for that warm welcome, and thank you for the hospitality that's been extended to me today. I'm honored this afternoon to be here, and I'm honored by your presence here this afternoon. And thank you, Lisa Hull, for that very generous introduction. I'm delighted to be back at Christ Church. I say back because, as you heard, I had the opportunity, the privilege of speaking here quite a few years ago now. And in fact, I had the privilege of speaking from the top deck of that magnificent pulpit. You'll know what I'm talking about. You don't realize how high off the ground that is until you're up there. Now, I've never given a lecture on stilts, but I imagine that that's a little bit what it felt like to talk on stilts, because you're so high up in the air. Some 40 years ago, in the year of the bicentennial of the United States Constitution, a clever wordsmith for the Virginia Commission on the Bicentennial coined an ingenious, a truly inspired slogan. A slogan that was displayed prominently on the Commission literature and other statewide material at the time. And the slogan read, "The Constitution, it has Virginia written all over it." And there's a lot of truth, I think, packed into that simple tagline. And in this season of America 250, as we commemorate the 250th anniversary of the signing of the United States Declaration of Independence, I was reminded of those words, and I think we can say in truth and all sincerity, the United States Declaration, it has Virginia written all over it. Now, I want to take a little bit of time this afternoon to sort of investigate that claim. In 1776, Virginia was the largest, most populous, most prosperous, most influential of the former colonies of Britain. It sort of lay at the crossroads between North and South. And so what happened in Virginia mattered a great deal. And people around the country watched what was going on in Virginia. And it's going to play a decisive role in the movement for independence. And so again, people across the former colonies were observing what's going on in Virginia. As John Adams of Massachusetts wrote to Patrick Henry of Virginia in June of 1776, these are anxious times. He says, "We all look up to Virginia for examples." Now, more directly on point, I think it's hard to imagine the Declaration of Independence absent the hand and the heart and the mind of that Virginian, Thomas Jefferson. But I want to direct your attention to another sense in which Virginia informed, laid the foundation, if you will, for the Declaration of Independence. These foundations, like the Declaration of Independence, were laid 250 years ago this year. And this afternoon I draw your attention to a document that was adopted by the Virginia Convention on June the 12th, 1776. A document that to this day remains a part of the organic law of the Commonwealth. It's a document worthy of not only commemoration, but I believe celebration. And I'm referring here to the Virginia Declaration of Rights, which was adopted unanimously by Virginia's 5th Revolutionary Convention, again on June the 12th of 1776. A case could be made, and I'm going to try to make that case this afternoon, that the Virginia Declaration is the most influential, the most imitated constitutional document in American history, leaving its mark on numerous subsequent declarations and bills of rights, as well as on the U.S. Declaration of Independence, which was written and adopted just a few weeks after the adoption of this document. The Virginia Declaration is often described as the first modern Declaration or Bill of Rights in America. It's a distillation of the great principles of liberty and constitutionalism that revolutionary Americans had come to believe were derived from English traditions and more generally from Western culture. George Mason of Fairfax County, who is credited oftentimes as its principal draftsman, boasted that the Declaration was the first of its kind on the American continent, and imitated widely, I think he correctly noted, by other newly independent states. Again, said to be the first Bill of Rights, Declaration of Rights, that was adopted by a duly elected representative assembly. And I think that's what distinguishes it from some perhaps other efforts that we find earlier in the colonial experience in declaration writing or bills of rights writing. By the end of the 18th century, most of the newly independent states had either framed a Bill of Rights or had enacted legislation that contained features that you might expect to find in a Declaration of Rights. Many of these states, including Pennsylvania, Maryland, North Carolina, Vermont, Massachusetts, and New Hampshire, either directly or indirectly borrowed language, content, and form from the Virginia Declaration of Rights. Still later state declarations of rights written after the founding era drew on the work of Mason and the Virginia Convention. The Declaration similarly informed proposed amendments to the national Constitution that were debated and recommended in state ratifying conventions. Again, a number of states, North Carolina, Virginia, for example, when they sent their proposals to the first Congress as to how they would like to see the Constitution that came out of Philadelphia revised, they simply repackaged the Virginia Declaration of Rights. And so the proposals that ended up in the first Congress that debated the language that would eventually become what we call the Bill of Rights is going to draw heavily on Mason's work and that of the Virginia Convention. And so the product, those amendments we today call the Bill of Rights, bear the unmistakable influence of Mason's work. It is also said to have informed declarations of rights beyond America's shores, including the French Declaration of the Rights of Man and of Citizen, adopted in 1789. Jefferson, you'll remember, had served shortly before as the American ambassador or minister to France. And there's evidence that he shared a copy of the Virginia Declaration with the old friend Marquis de Lafayette, who played a large role in crafting that French declaration. It's also said to have left its mark on the United Nations Universal Declaration of Human Rights that was proposed and adopted in the mid-20th century. So again, the influence is spreading across the globe as we know it. But perhaps most important, the Virginia Declaration's opening lines, and see if this language sounds familiar to you, stated, and I quote, "All men are by nature equally free and independent and have certain inherent rights, namely the enjoyment of life and liberty with the means of acquiring and possessing property and pursuing and obtaining happiness and safety," end quote. This language almost certainly informed the key language of equality and inalienable rights in the second sentence of the U.S. Declaration of Independence. And this would become the most celebrated and succinct expression of America's defining founding principles. And again, this is a formulation first found in the Virginia Declaration of Rights. Now, just by way of a quick summary, and I'll come back and look at this in a little bit more detail, the Virginia Declaration, as enacted, contains 16 articles affirming humankind's inherent natural rights, the importance of limited government, and government by consent of the governed. It was rooted in and devoted to the essential principles of republicanism. And what did that mean? That meant that power is vested in and derived from the people and exercised through their duly elected representatives. Now, the Declaration goes on to enumerate, among other things, the rights of criminal defendants to be informed of accusations, the right to a speedy trial and impartial jury, the privilege against self-incrimination, prohibition on cruel and unusual punishments, and unreasonable searches and seizures. Provisions that should all sound familiar to us, right? It also includes strong language in defense of freedom of the press. And as I'm going to talk a little bit more later, the free exercise of religion. Now, it must be noted that there were Virginians in 1776 who recognized a dissonance between the Declaration's claims of freedom and equality and inherent rights for all men and the Commonwealth's maintenance of the institutions of slavery. And again, this is a point that I'm going to come back to and talk about a little bit more in a few minutes. Now, Virginia's 5th Revolutionary Convention assembled in Williamsburg on May the 6th, 1776. On May 15th, the convention passed a resolution instructing the Commonwealth's delegates at the Continental Congress to press for independence from Great Britain. So I think we could say, and this is not, I think, stretching things too far, I think that we could say that May 15th, in essence, is Virginia's Declaration of Independence. And by the way, I expect to see you all out next May 15th shooting your fireworks off and the barbecues running. So, but I think, again, I think it's fair to think of May 15th as Virginia's Declaration of Independence. This bold initiative, however, raises some really troubling questions about the nature of civil authority extant in the Commonwealth, right? If you declared independence, what's the authority? What's the governing authority in Virginia on May 16th? It's a challenging question if you think about it. Believing perhaps that they had reverted to what someone like John Locke might call a state of nature, the delegates thought it necessary to frame a new social compact, beginning with a declaration of humankind's natural rights, followed by a new plan or constitution of government. And so that same convention that pressed for independence also appoints a committee with the task of writing a Declaration of Rights and a new constitution. Now, among those appointed to this committee were George Mason and the young, untested delegate from Orange County by the name of James Madison, Jr. This, we might say, was Madison's very first venture on the political stage. Of course, he would go on to have a very storied career in politics, but this is his first stage, right? Has a little bit of an unusual story for a Virginian, right? He didn't go to William and Mary. Remember where he went to college? Princeton. He went to Princeton, right? A little bit unusual, Presbyterian college. Comes home, back to Orange County, lays around the house, and Father says, son, you're going to have to do something worthwhile for your life. And what does he do? He goes into politics. Right? We can debate whether he followed his father's advice or not. Now, George Mason, the famous George Mason is George Mason IV of Gunston Hall on the Potomac, which is just south of Mount Vernon, who's generally credited as the chief draftsman of the Virginia Declaration of Rights and the Constitution of Virginia in 1776. He plays a pivotal role in important assemblies of both his state and his nation. He was a member of the Virginia Conventions that met both in 1775 and again in 1776. He, of course, is a Virginia delegate at the Constitutional Convention that met in Philadelphia in the summer of 1787. He goes on to take a leading role, a losing role, by the way, in the Virginia Ratifying Convention in June of 1788. And he, in the course of all this, is going to contribute to some of the key political documents of the American founding era. Now, Mason had inherited substantial land holdings in Northern Virginia and in Maryland, and he later speculated heavily in Western lands. He was also one of the Commonwealth's leading slaveholders, and the labor of the enslaved was integral to the work of his plantation. Although he had little formal education and no formal training in the law, he was well read in the law and the so-called ancient English Constitution. And he's going to draw on this knowledge in articulating the colonists' claims against Great Britain and in framing the Virginia Declaration of Rights and its first Constitution. Some of you may remember the story of George Mason. It's an interesting one. He is being groomed, perhaps to be sent to England to study at the Inns of Court. But when he was only 10 years old, his father was drowned in a freak boating accident crossing the Potomac River. And so suddenly at the age of 10, he's the man of the house, so to speak. Now, one of his uncles, John Mercer, was one of the leading lawyers in Virginia, said to have had the best law library in Virginia. And he encouraged Mason to read and study in that law library. And so even though George Mason did not have formal training in the law, his contemporaries recognized that he was perhaps one of the best legal minds in Virginia. Again, never practices law, but yet he read deeply from his uncle's law library. And it puts him in a really a strong position when it comes to the later tasks of his life. Now, sometime in late May, Mason prepares a draft of the Declaration of Rights. He prepares some 10 articles to which other measures were added by members of that committee that were charged with drafting this declaration. A committee draft of the Declaration was printed and disseminated up and down the Atlantic seaboard in early June. And it's going to have an enormous impact on compatriots in the nascent states engaged in the task of creating new governments in the wake of independence. Just as an interesting side note, we're still not yet to the final draft. This is a committee draft, but this is the draft of the Virginia Declaration that's going to have enormous influence across the country. It's printed and distributed. It's the copy that makes its way up to Philadelphia. It's the copy that Jefferson is going to be reading up in Philadelphia. Again, not the final draft, but rather the penultimate draft of the Virginia Declaration. I think it has a lot to do with the way in which information was disseminated in colonial America, right? It'd be published there in Williamsburg, and it would be published again maybe up the river in Richmond, and it would go up. And so it works its way across the country. Again, this preliminary draft, not the final draft, that has such enormous influence and impact across the former colonies. Now, the convention debated and amended drafts of the Declaration before it was passed unanimously on June the 12th. And just to round out the story, a couple weeks later, on June the 29th, is when they passed, again, unanimously, the first Virginia Constitution following independence. Now, the genius of Mason's Declaration of Rights was not that it expressed original principles. Rather, it distilled and harmonized the Republican sentiments of the day, brilliantly summarizing the objectives of those Americans who aspired to be independent and self-governing. With remarkable brevity and clarity, it condensed the great principles of political liberty derived from the English common law and constitutionalism, including principles extracted from Magna Carta, the Petition of Rights in 1628, and the English Bill of Rights of 1689. It encapsulated that struggle to establish parliamentary supremacy, culminating in the glorious revolution of 1688, 1689. This is the revolution that brings William and Mary to the throne. It combined a commitment to fundamental liberties with a brief expression of constitutional principles and political ideas expounded by a John Locke and a Baron de Montesquieu and other political philosophers, both ancient and modern. Now, as I say, the Declaration, as enacted, contains 16 articles. Most important, the first article affirmed the inherent natural rights of life, liberty, property, and the pursuit of happiness and safety. It firmly established the essential principles of Republican government as Americans in the Revolutionary Age had come to understand republicanism. And by that they meant all government power is, and I quote from the Declaration, vested in and consequently derived from the people, end quote. This power is exercised through freely and fairly elected representatives of the people. Civil magistrates and trustees are servants of the people and amenable to them. And no office of public trust is to be hereditary. This again is an encapsulation of what republicanism would have meant to Virginians and Americans more broadly at this time in history. The Declaration also required the separation of the state's legislative and executive powers from what they called the judicative. Didn't quite get that out, but in essence what we would today call the judiciary, right? The judiciary department. So it's crafting those three branches of government as we have come to understand them today. It recognized the unalienable right of a majority of the community to reform, alter, or abolish any government that fails to provide, and I'm quoting here again, for the common benefit, protection, and security of the people, nation, and community, end quote. It disallowed taxation or the deprivation of private property for public use without consent of the people's representatives. And it placed the military under civilian control. The Declaration also goes on to enumerate rights free from government restrictions. Among them are the rights of a criminal defendant to be informed of accusations, confronted with the accusers and witnesses, to call for witnesses on one's behalf, the right to a speedy trial by an impartial jury of one's vicinage. It upheld the privilege against self-incrimination, disallowed the deprivation of liberty without due process of law. Borrowing language here from Article 39 of Magna Carta, comes straight out of Magna Carta. It prohibited excessive bail, excessive fines, cruel and unusual punishments. Here it's taking language right out of the English Bill of Rights. And by the way, the language from Article 9 of the Virginia Declaration of Rights is going to show up as the Eighth Amendment to the United States Constitution. Word for word, comma for comma. It also prohibited the searches and seizures by use of a general warrant, right? What does our Fourth Amendment require? That there be specificity in securing warrants for searches and seizures. This is an effort to disallow these broad warrants that the king had been using against the colonists. It also expressed a preference for the ancient trial by jury in civil disputes and affirmed the freedom of the press. It declares that freedom of the press is one of the greatest bulwarks of liberty. And it provided in Article 16, the final article, protection for the free exercise of religion. Notably, the Declaration failed to include some provisions that would be familiar features in later American Bills of Rights. So it's almost as interesting what it did not include as what it did include. And so what are we referring to? It did not make mention of the right to free speech and assembly. It did not mention the right to a writ of habeas corpus, or it did not prohibit double jeopardy, nor did it provide for the use of grand juries, or provide for the right to legal counsel. Some of these, I think there are some good explanations why they're not included. Others, it's hard to say, right? He's trying to be very, very brief here in capturing what is most important at the moment. And so perhaps that may account for why some of these ideas are not included in that document. The first article in Mason's draft of the Declaration had famously proclaimed, and I'm going to quote here, that all men are born equally free and independent and have certain inherent natural rights, among which are the enjoyment of life and liberty with the means of acquiring and possessing property and pursuing and obtaining happiness and safety, end quote. Now again, I hope that language sounds a little familiar to you, even if you've not encountered the Virginia Declaration before. Why? Because in the Declaration of Independence, this language was borrowed and it was revised. And what do we read in the Declaration of Independence? That all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. Now the formulation of the Second Continental Congress, the U.S. Declaration of Independence, drawing on Mason's language, is arguably the most famous example of American revolutionary rhetoric. And it's an essential expression of the American political creed. Both Mason's version and Jefferson's revision cast light on this uncomfortable relationship between natural rights claims and the institutions of slavery. Clearly, Mason's original version was unsettling to some leading political figures in Virginia and in the Virginia slaveholding society, who worried that these words could undermine the institutions of slavery in Virginia. The contradiction of slaveholding Virginians declaring that all men are born equally free and independent, possessing inherent natural rights, is a difficult one to get your mind around, right? And it's difficult to sort of miss this contradiction, this dissonance of ideas. The apparent universal character of the natural rights claims of the Declaration is going to compel consideration of its implications for enslaved people here in Virginia. Could this language be used, think about this, could this language be used to assert freedom for and invite insurrection by enslaved peoples, or to extend full participation in civic life, including suffrage to those men and women previously excluded from an active role in the political society? Now, there's much that could be said about the patriots' passionate rhetoric of liberty and equality for all men while maintaining the institutions of slavery. And again, few people of that day did not miss that contradiction. It was just front and center in their minds, and it shows up in their conversations and their letters and writings. But what I want to ask is a slightly different question here, which is this. What can we say about this topic looking back through the lens of the Virginia Declaration of Rights? I think we can say that the immortal words of all men are born equally and free and independent, as expressed in Mason's draft, as refined and amplified in the Declaration of Independence, compelled Virginians and people throughout the new nation and around the world to confront this contradiction and to commence conversations that would culminate, not immediately, but eventually, in the abolition of slavery in Virginia and in the new nation. These words provoked arguments and set in motion movements that would ultimately undercut and uproot slavery and affirm the rights of all humanity. In other words, what I'm suggesting to you is, I think in the absence of this language that we find in the Declaration of Rights, as amplified through the U.S. Declaration of Independence, it would have taken much longer for Americans to abolish slavery. Now, the Declaration's 16th and final article, protecting the free exercise of religion, is perhaps the document's most original and important American contribution to political thought and practice. Just a minute ago, I said that the genius of the Declaration is not in its original ideas, but its distillation of long-standing ideas in the Anglo-American tradition. Now, having said that, I think there's something profoundly innovative that comes out of Article 16 of the Virginia Declaration of Rights. This is an article that's going to enshrine protections for religious exercise, protections that far exceeded what George Mason had initially proposed, and indeed would go beyond the most liberal policies found in much of the Western world at that time, and even to the present time. Just so we know exactly what we're talking about, let's look very quickly at Article 16. This is Article 16 in its totality. And this is what it says, that religion, or the duty which we owe to our Creator, and the manner of discharging it can be directed only by reason and conviction, not by force or violence. And therefore, all men are equally entitled to the free exercise of religion, according to the dictates of conscience. and that it is the mutual duty of all to practice Christian forbearance, love, and charity towards each other. Now, before we sort of dig into this language, and I want to point out some really significant things that I think are going on here, let's talk a little bit about what protections there were for religious exercise in Virginia at the end of the colonial era as we move to Article 16. I want us to get a picture of what the rights of religion looked like before, right? I have here in my notes the protections, or perhaps the lack of protections for religious exercise found in the laws of Virginia prior to independence. There were, in addition to the established Church of England, multiple dissenting sects throughout the Commonwealth. And they, to be fair, enjoyed a measure of toleration and belief and religious belief and exercise. Although they were often burdened in the exercise of their religion and subjected to disabilities in the exercise of their civic prerogatives. Let's note that some dissenting sects, most notably the Baptists, were growing rapidly in membership, and this was alarming, even threatening to some in the established Church of England. Now, dissenters in those days had to pay taxes to support the established church. This, by the way, is in addition to their voluntary supports for their own churches, right? So, in a sense, they're kind of being double taxed, if you will. They had to regularly attend services of the established church. I think at the time you had to attend one service a month, if I remember correctly, right? You had to have a license or register the meeting house of your dissenting sect. You also had to have a license to preach. Ministers of these dissenting sects had to have a license to preach. And this, by the way, made it almost impossible for itinerant evangelists to preach, right? There just was not time as they moved. It essentially outlawed revival, sort of moving revival meetings. Baptist ministers in particular vigorously resisted licensure requirements, arguing that their license to preach came from God, not the civil state. In fact, dissenting Baptist ministers were thrown in jail in Central Virginia in the mid-1770s for refusing to secure a license to preach. There are accounts of imprisoned Baptist ministers preaching to their flock through prison bars. Where I live in Northern Virginia, just walking distance from my home is the spot where a very well-known Virginia Baptist minister by the name of Jeremiah Moore lived, and he's buried there, again, just almost a stone's throw from where I live. And he famously would preach to large flocks through the prison bars there in Northern Virginia. But this is a picture of what quote-unquote toleration looked like in Virginia before Article 16. Now let's look at Article 16 again. It declares that all men are equally entitled to the free exercise of religion according to the dictates of conscience. It's the lower quote there on that screen. This formulation was proposed by James Madison, replacing Mason's initial draft affirming that all men should enjoy the fullest toleration in the exercise of religion according to the dictates of conscience. And again, I made reference to this a minute ago, but I'll say it again. Madison's proposal of this amendment is his first known act as a political figure in his entire career, right? He first introduces himself to politics by advocating in defense of religious liberty. Now, let's look at Mason's language, right? The fullest toleration, the fullest toleration. This reflected the most liberal and enlightened policies of the age, but it did not go far enough to satisfy Madison. Madison's revision, again the lower quote there, emphasized one of the most important insights of American political thought. A state policy of religious toleration dangerously implied that religious exercise was a mere privilege that could be granted And if it can be granted, it can then be revoked by the civil state. And that's what Madison is objecting to, right? Toleration sounds so good, but it implies that there's an authority, the civil state, usually operating in concert with the established church, is in its benevolence saying you can practice your religion, but if they have that authority to grant you that, they can then also take it away. And Madison says there's a different foundation for thinking about religious exercise. That is to put it on the foundations of natural rights. Natural rights. Religious liberty, as Madison is contending here, is that religious exercise is a natural, indefeasible right possessed by all citizens, placed beyond the reach of civil magistrates and subject only to the dictates of a free conscience. Right? It's a radical rethinking of the foundations upon which one may exercise their religion. Now, key to Madison's revision is this word equally. This emphasized that the religious rights of dissenters, think about those dissenters out there in the Shenandoah Valley and moving on into the Appalachia Hills, they had rights to practice their religion that were equal to those of elite Anglican members of the established church living in the Tidewater. All citizens, including religious dissenters and nonconformists, enjoyed absolute equality in religious belief and practice. Now, one of the things I find fascinating about the debates over Article 16 is that we find both in the debates surrounding that language that we looked at just a minute ago, but also the text itself. They're going to address some core issues that vexed debates over religious liberty then, and interestingly enough, continue to be the same issues that roil debates about religious liberty today. And they're going to touch on almost all of the key religious liberty issues that have been played out in America over the course of the last 250 years. And it's going to start with the question of how do you define religion, right? If we're going to protect religious liberty, what is this thing that we're protecting or perhaps not protecting? And you may remember that's the first thing addressed there in Article 16, defining religion. And what does it say? Religion, or the duty which we owe to our Creator, right? It's giving us a definition. Now, religion, as Mason defined it, necessarily arises from the duties we owe to our Creator. It may not encompass any and all deeply held beliefs, even though they might, in some sense, parallel beliefs involving the Creator. Now, let's note, however, even though there may be some deeply held beliefs not protected by Mason's definition of religion, they may find protection in other provisions, such as freedom of the press, for example, or some kind of freedom of association of some sort, right? But he's defining it in clearly in terms of the Creator. Now, this is a definition, by the way, of religion that's going to reverberate through the political and legal discourse of the age. This is the definition that James Madison adopts some 10 years later when he writes his famous remonstrance against general assessments, a famous document that he writes in June of 1785. Now, the Virginia Declaration, starting with Mason's initial draft, affirmed that religious liberty is concerned with not only one's religious belief, but also the manner of discharging it. The manner of discharging the duties which we owe to our Creator. Now, the reason why I emphasize this, because there is a long-running line of arguments that you find in American history, even at one time, not today, but at one time, well over 100 years ago, in which the Supreme Court of the United States says religious liberty means you can believe whatever you want. You just can't act on that belief, right? Now, this is sort of challenging that idea, right? Because what's being embraced and protected here is not only belief, but the manner of discharging that belief. It protects the conduct or the practices that follow from that belief. Article 16 affirmed that religion can be directed only by reason and conviction, not by force or violence. Right? Direct quote here from Article 16. This, in fact, forms the very rationale for religious liberty. Religious liberty requires a free and open marketplace of ideas for people to inquire, to learn, reason, persuade, form opinions, and believe, free from external coercion, restraint, or persecution. This is what Jefferson is going to address in his very famous Statute of Virginia establishing religious liberty. You may remember this is one of the three things that Jefferson wanted to be remembered for on his gravestone, the Virginia Statute. And he's going to come back to this very point. And this is the language that he uses. Now I'm going to Jefferson here. And Jefferson writes, Almighty God hath created the mind free, and manifested his supreme will that free it shall remain, by making it altogether insusceptible of restraint. That all attempts to influence it by temporal punishments or burthens or by civil incapacitations tend only to beget habits of hypocrisy and meanness, and are a departure from the plan of the holy author of our religion, who being Lord both of body and mind, yet chose not to propagate it by coercions on either, as it was his almighty power to do, but to extend it by its influence on reason alone. End quote. Right? So Jefferson himself, I think, is going to buy into this idea. And Jefferson's going to go on to say in that Virginia statute, it is sinful and tyrannical to compel a man to support or furnish contributions for opinions he disbelieves and abhors. If God created the mind free, and if it is his will that it should remain free, then to deny freedom of conscience and religious liberty is contrary to God's will for humankind, and it's an offense. We might even say a blasphemy against God. Now, both Mason and Madison acknowledged that all men should be entitled to exercise their religion according to the dictates of conscience, unpunished and unrestrained by the magistrate. Now, this language suggests that religious duties are prior to civil obligations. Thus, the exemption of religion from the authority of the civil state and the civil state's recognition of and protection for the exercise of religion. James Madison, again, some years later, citing Article 16, elaborated on this point in his famous Memorial and Remonstrance. And this is what he says. He says, the duty we owe to the Creator is precedent, or prior, precedent, both in order of time and in degree of obligation to the claims of civil society. Before any man can be considered as a member of civil society, he must be considered as a subject of the governor of the universe, end quote. Again, this is Madison writing in 1785 in his Memorial and Remonstrance. Another significant insight regarding the appropriate scope of religious liberty emerged from the convention's debates. Mason's initial draft authorized a civil magistrate to restrict conduct if, and I quote, under color of religion, any man disturb the peace, the happiness, or safety of society or of individuals. Now, let's be very clear. This is a question that goes to, are there limits to religious exercise, to religious liberty? That's what's being addressed in this quote. And we just see here what Mason says. Now, Madison, he urged his fellow delegates to adopt a more expansive understanding of the free exercise of religion that disallowed the magistrate from interfering with the free exercise of religion unless the preservation of equal liberty and the existence of the state are manifestly endangered. Now, both Mason and Madison are acknowledging that there may be limits on the exercise or conduct done in the name of religion, but they're drawing the line in a very different place. And I want you to notice the different places where they're drawing the line. Mason, in short, gave the civil magistrate, that is to say the civil government, broad powers to restrain religious exercise that disturb the peace and happiness of not only society but also individuals. I've been interfered with a few times by street preachers, right? Mason would seem to draw the line to protect me rather than the street preacher. But Madison's going to draw the line in a different place. He's going to espouse a principle of no interference with the free exercise of religion except to preserve equal liberty, fundamental security, and the very existence of the civil state. Again, Madison's vision of protected religious exercise was much more expansive than Mason's. And I'm going to say, Madison wins this debate. And it's the Madisonian view, I think, that's going to be enshrined in what we call the First Amendment to the Constitution. It's a more expansive view of what's protected by the free exercise of religion. Finally, one last issue that I want us to address that comes out of the debates on Article 16. A proposed amendment to what would become Article 16, Madison included this language, and I'm going to quote, "Therefore, that no man or class of men ought on account of religion to be invested with peculiar emoluments or privileges," end quote. Think about the significance of that language. What would it have done? This language, if adopted, would have effectively terminated an officially established church in Virginia. But this is language that proved too radical for the times, and the language was dropped, and the Church of England remained, and I'm going to say technically remained, the established Church of Virginia for a few more years. But its power and its influence is going to be severely diminished by the very debates and the passage of Article 16 of the Virginia Declaration of Rights. And let me just say that one more time. Article 16, it's, I think, often said, but it's a mistake, I believe, it's often said that Article 16 led to the end of the established church in Virginia. It doesn't technically, but it clearly clips the wings of the privileges and benefits that the Church of England had formerly enjoyed in Virginia. In the penultimate article of the Virginia Declaration, the framers reminded citizens what is required for the maintenance of free government and the blessing of liberty. These can be preserved. Again, free government and the blessing of liberty. These can be preserved only by, and I'm going to quote, a firm adherence to justice, moderation, temperance, frugality, and virtue. Mason thought these were the essential principles, the essential virtues of republican government. And then, as if to underscore the Declaration's perpetual vital importance to Virginia's experiment in republican self-government and ordered liberty, the article counseled, "No free government or the blessings of liberty can be preserved to any people but by frequent recurrence to fundamental principles." Nowhere in the Commonwealth's organic law are those fundamental principles expressed more succinctly and eloquently than in the Virginia Declaration of Rights. And I think that's why we gather here today. That's why we commemorate America 250. That's why we commemorate the Virginia Declaration of Rights 250. It's an opportunity to make frequent recurrence to those fundamental principles. So let us, in this year of America 250, and in this year of the 250th anniversary of the signing of the Declaration of Independence, pledge to make frequent recurrence to the fundamental principles so eloquently articulated in the Virginia Declaration of Rights, so that we may continue to enjoy in this land a free government with the blessing of liberty. Thank you for your time.